It's not the story they tell you that is important. It's what they omit. It's not the story they tell you that is important. It's what they omit. It's not the story they tell you that is important. It's what they omit. It's not the story they tell you that is important. It's what they omit. It's not the story they tell you that is important. It's what they omit. It's not the story they tell you that is important. It's what they omit.
So what if the biggest, the most aggressive legal battles in this country aren't actually designed to be won?
Right. Like they're just...
Yeah, exactly. Like, what if instead of being genuine disputes over the law, they are just these highly engineered, incredibly expensive traps?
That's crazy thought.
It really is. I want you, the listener, to just imagine a scenario for a second. Imagine a scenario that's designed specifically to drain the resources, the time, and, the investigational capacity of an entire legal apparatus for exactly 12 months.
Just a massive sinkhole for time and money.
Exactly. And what if the ultimate goal of that massive, highly publicized battle is simply to ensure that the evidence that actually matters, the evidence locked away in a completely different jurisdiction, is permanently silenced?
Right.
Today, we're looking at a document that claims exactly that architecture is playing out in real time, right now.
It really is a profound shift in perspective.
Yeah.
Because, we are so conditioned to look at the scoreboard. Right?
Oh, absolutely. Who's winning, who's losing?
Right. We watch the news, we look at the high-profile court cases, and we just ask, who is winning the argument?
Right.
But the source material we are examining today, it forces us to ask a much more unsettling question, I think. It asks, who built the courtroom? Mm-hmm. And, what evidence did they intentionally exclude from the building before the argument even started?
The fight over Virginia redistricting is a genuine constitutional conflict. The core question, Whether a state legislature can use a mid-decade referendum to functionally erase the representation of a regionally coherent minority is a real substantive issue. It is an issue that demands rigorous litigation. State attorneys general, the Department of Justice's Civil Rights Division, congressional oversight committees, and private election law firms are legally and arguably morally obligated to engage with it on the merits. The legal frameworks involved are heavy. Any courtroom addressing this will be weighed down by the 14th Amendment's Equal Protection Clause and the strict established doctrines of the Voting Rights Act. Because the legal fight is constitutionally real and requires a full-scale response, it serves as an effective lure. To understand why, we have to look at the math of investigative capacity. Every investigative committee and Attorney General's office operates with a finite amount of staff, budget, and time. The Virginia legal battle is positioned to consume the entirety of that resource for the next 12 months. This exhaustion of capacity protects an unadjudicated evidentiary record, forensic images of election servers from the 2020 cycle that have sat idle for 5 years. By drawing every available investigator into the Virginia redistricting fight, the adversary starves this 2020 forensic evidence of the legal talent needed to bring it before a neutral tribunal. This strategy is designed to safeguard a specific prosecutorial doctrine. It is a legal architecture that has successfully kept these 2020 images silenced in every jurisdiction where they exist. The objective is not to destroy the evidence, it is to permanently distract the personnel who would otherwise act on it. The architecture of the Virginia Fulcrum relies on 2 pre-engineered legal exits. Exit 1 is validation. If the courts validate the redistricting, it triggers a regional secession escalation in Southwest Virginia, locking legal teams into a compounding state-level fight. Exit 2 is invalidation. If the courts strike it down, the entire investigational theory driving the current momentum collapses into a procedural dead end. Both procedural paths result in the total abandonment of the 2020 forensic data by the legal apparatus. The fulcrum exists to drain finite legal resources over the span of an election cycle. From a strategic standpoint, it doesn't matter who legally wins or loses the state redistricting case. To understand the evidence being protected, we have to look at the 2021 voting system imaging authorized by former Mesa County Clerk Tina Peters. When Colorado prosecuted her, the trial court established the first step of the doctrine. It excluded her intent. Her belief that she was performing a statutory preservation duty was ruled legally irrelevant, criminalizing the act of preservation itself. Then came step 2. At sentencing, the court reintroduced that same intent, weaponizing it to brand her a malicious charlatan. Step 3 is silencing the evidence. The forensic material is ignored because the custodian has been publicly and legally delegitimized. This parallel structure applies to the preserved forensic images of Pennsylvania election system servers captured during the 2020 cycle. It has been ignored and unadjudicated for the same reasons. The doctrine suppresses physical evidence without a neutral tribunal ever having to evaluate whether the data itself is valid. This is where the Virginia trap and the silenced forensic evidence connect. It comes down to the boundaries of legal jurisdiction. The Virginia fight is governed entirely by partisan gerrymandering doctrine, state constitutional amendments, and the Voting Rights Act. These legal frameworks prohibit the introduction or adjudication of preserved forensic data from a prior election cycle. Legal teams are being herded into a venue where their primary evidence is structurally barred from being heard. The trap forces the opposition to fight exhaustively in a courtroom that is structurally incapable of hearing the case. Field conditions are tightening. The opposing coalition is currently enforcing a strict internal communications discipline. They are migrating internal comms to Signal, a move that indicates concern over endpoint compromise, the vulnerability of the physical devices themselves. This operational shift suggests they expect impending adversarial scrutiny and are preparing for it before it reaches the public record. The window for action is compressed. The deployment scheduled for Mayday is only 7 days away. Time is the resource that can no longer be spent in a decoy jurisdiction. For officials weighing a response, the rules are specific. Use a multi-jurisdictional lens, maintain a disciplined response, document choreography in real time. A procedural strategy already exists to link the Virginia litigation directly to the adjudication of the Colorado and Pennsylvania evidence. This strategy is being withheld from the public record to preserve operational surprise. It is reserved for secure, hand-to-hand delivery to vetted officials through trusted intermediaries. While the news cycle broadcasts the story in Virginia,
the actual evidentiary record remains omitted from the legal process. The only defense against a jurisdictional trap is to build the courtroom structurally designed to hear the case.
It's not the story they tell you that is important. It's what they omit.
Welcome to today's deep dive. Our mission today is to unpack a really highly sensitive, intensely detailed briefing. It's authored by an individual who goes by the name Tor.
And it is dense.
Oh, it's incredibly dense. We're going to map out a highly sophisticated procedural trap that the author claims is currently active in the legal system. We're going to define what the text calls a prosecutorial doctrine.
Which is fascinating, by the way.
It's totally wild. It's basically a mechanism specifically built to silence preserved forensic evidence. And then we're going to outline the precise cross-jurisdictional strategy that legal teams supposedly must execute to break this trap before a rapidly approaching deployment deadline known as Mayday.
Right, the ticking clock. But before we pull apart the mechanics of all this, I think we really need to establish a very clear baseline for this discussion.
Good idea.
Because the briefing we are analyzing today, it touches on some of the most highly charged, intensely polarizing political issues in the country right now.
Yeah, it definitely does.
Specifically, it centers on the preservation of forensic records from the 2020 election cycle, the ongoing Virginia redistricting fight, and some pretty massive allegations involving major tech infrastructure.
Right.
So I want to be unequivocally clear here for you listening. Our role today is not to validate or endorse or debunk any specific claims about election integrity or political outcomes.
We are definitely not taking a side here.
Exactly. We are not taking a position on the underlying political disputes whatsoever.
Right. We are just looking at the architecture of the legal argument, not endorsing the outcome.
Spot on. We are acting strictly as impartial guides through the author's logic. We're just here to map out the fascinating legal strategies, the procedural maneuvers, and the underlying structural arguments that are detailed entirely within the four corners of this document.
Just reading the map they gave us.
Exactly. It's a masterclass in procedural theory, really. And that is what we're analyzing today.
Okay, so let's look at the first massive structure on this chessboard. The author introduces a concept they call the Virginia Fulcrum.
The Fulcrum.
Yeah. And this centers entirely around the current Virginia redistricting fight.
Right now, the entire conservative political apparatus is pointing at the Virginia redistricting fight as the essential legal battleground for election integrity. On its own merits, it looks like a serious dispute. Lawyers are gearing up to debate state constitutional amendment doctrines, the Voting Rights Act, and complex questions about partisan gerrymandering. However, the structure of this litigation is designed with two specific exits. Whether the challenges are validated or invalidated, both results lead to the same functional endpoint. By funneling every conservative-aligned officer of the court into this single jurisdiction, the operation consumes the next 12 months of investigational capacity. This concentration of resources creates a vacuum, drawing attention away from the actual evidentiary record and onto a legal fight that is structurally incapable of addressing it. While attention is fixed on Virginia, a specific legal doctrine has already been tested in Mesa County, Colorado. It began when a local clerk captured forensic images of voting equipment to preserve data before a scheduled trusted build modified the system. The state prosecuted her for that act of preservation. At trial, the court ruled that her intent, her belief that she was fulfilling a statutory duty, was legally irrelevant to the charges. Yet at sentencing, the court reversed its posture and weighed that same intent against her. The judge characterized her beliefs as pretextual and malicious, labeling her a charlatan peddling snake oil. On the basis of that characterization, the same intent excluded from the trial's merits, the court sentenced her to 9 years in state prison. This sequence allows the legal system to criminalize the custodian, while ensuring the substantive content of the forensic material she preserved is never reviewed by any court. This mechanism is now being applied to parallel forensic material preserved during the 2020 election cycle in Pennsylvania. That data was captured under the same statutory principle that a custodian has a duty to secure the record before mandated procedures alter the underlying information. The Pennsylvania material remains preserved and available for review, yet it has never been contested, rebutted, or analyzed by any neutral tribunal. The doctrine prevents the evidence from being heard by criminalizing the person who holds it, creating a chilling effect that silences the record without ever addressing its substance. The result is a structural machine that keeps all 2020 forensic material functionally silenced, regardless of what it contains. This is where the Virginia redistricting fight reveals its true function within the broader strategy. The laws governing the Virginia case, redistricting doctrine and the Voting Rights Act, do not permit the adjudication of forensic material from prior cycles. That courtroom is jurisdictionally barred from hearing the evidence. As long as the investigational apparatus is locked in the Virginia litigation, it is not building the framework required to challenge the doctrine, keeping the 2020 record buried. The trap is the consumption of capacity. It ensures every officer of the court is fighting in a room where the actual evidence is legally inadmissible. The primary point of vulnerability for this doctrine is currently sitting in the federal habeas docket of the District of Colorado. A coordinated deployment begins on Mayday, leaving only 1 week for officials to pivot and execute a procedural response. Breaking the choreography requires moving past the public narrative and using the private procedural strategy to establish a courtroom that can receive the preserved material. Success depends on looking past the high-profile story being told and acting on the forensic evidence they are actively omitting.
Now, the natural assumption when you hear words like distraction or trap is to assume the issue itself is fake.
Right. Like it's just a frivolous lawsuit.
Exactly. But the author goes out of their way to establish that this redistricting fight is a very real, very serious constitutional issue.
It is absolutely not a frivolous lawsuit. The constitutional question at the heart of the Virginia case is profound. Mechanically, the conflict asks whether a state legislature possesses the legal authority, utilizing a mid-decade referendum amendment, to redraw congressional districts in a way that functionally erases the representation of a regionally coherent minority demographic.
Okay, let's break that down for a second, because mid-decade referendum amendment is quite a mouthful.
It's a lot of legal jargon, yeah.
Normally, redistricting happens every 10 years, right? Like after the census.
Precisely. Article 1 of the Constitution mandates a census every 10 years. And state legislatures use that data to apportion their districts.
Right. It's a huge deal.
It is a massive, highly contested process that takes years. But what Virginia is dealing with is a mid-decade alteration. This isn't the standard 10-year cycle at all.
It's happening out of nowhere.
Right. It's an attempt to alter the map outside of that normal rhythm via a referendum process. And the legal threshold to do that, especially when it threatens to dilute or erase minority representation, well, that triggers intense federal scrutiny.
Because you run straight into the Voting Rights Act.
Exactly. You run into the Voting Rights Act of 1965, specifically Section 2. That section prohibits voting practices or procedures that discriminate on the basis of race, color, or membership in a language minority group.
So it's heavy stuff.
Oh, very.
Yeah.
You also immediately triggered the 14th Amendment's Equal Protection Clause.
Yeah.
And you enter the incredibly complex doctrine of partisan and racial gerrymandering, which, the Supreme Court has spent decades trying to untangle.
Right, right.
The author explicitly states that this is a heavy, legitimate constitutional dispute. State attorneys general, the Department of Justice's Civil Rights Division, massive election law firms, they are all legally obligated to engage with this.
Because they have to.
Right. It requires hundreds of thousands of billable hours, massive data analysis, demographic modeling, and just endless depositions.
Okay, but if it is a real fight with real constitutional stakes, how is it a trap? I mean, if I'm a lawyer who cares about election law, I should be fighting this, shouldn't I?
Well, that is the genius of the trap. A good trap doesn't use a fake piece of cheese, right? It uses a real one.
Oh, that's a good way to put it.
The author argues that this legitimate constitutional fight has been strategically positioned as a fulcrum to basically consume capacity.
Consume capacity.
Yes. The trap is designed to consume the entire investigational bandwidth of the DOJ, conservative legal groups, and state AGs for the next 12 months.
So while they are totally consumed by, demographic modeling and equal protection arguments in Virginia, what are they missing?
They are missing the fact that the courtroom they're fighting in has fundamental jurisdictional limitations. Let's look at the mechanics of jurisdiction for a second.
Sure.
A judge in a federal or state court does not have infinite power to hear any grievance you bring them. They are bound by the specific statutes governing the case before them.
Right, like if you sue someone for breach of contract, you can't suddenly start bringing in evidence that they also committed a hit and run unless it's somehow directly relevant to the contract.
Exactly. Relevance and jurisdiction are the fences around the courtroom. In the Virginia case, the laws governing the dispute are redistricting law, the VRA, and the 14th Amendment.
Oh, okay.
Now ask yourself, do any of those legal frameworks provide a mechanism to adjudicate the forensic validity of preserved server data from an entirely different state from the 2020 election cycle?
Well, obviously not. If you're a lawyer in the Virginia redistricting case and you suddenly stand up and say, Your Honor, I'd like to submit forensic images of voting equipment from Mesa County, Colorado from 4 years ago, I mean, the judge is going to throw you out of the room.
The judge will sanction you honestly. They will say, Counsel, this is a hearing on mid-decade demographic shifts under the Voting Rights Act. I have absolutely no jurisdiction to examine 2020 election code.
Right.
And that is the crux of the trap. None of the frameworks in Virginia permit the adjudication of preserved forensic material from prior election cycles.
Let me just ground this with an analogy for you listening. Imagine you are driving a heavily armored truck. Okay. And inside that truck, you have undeniable, irrefutable security footage of a massive bank robbery.
Okay, I'm tracking.
You are trying to get to the FBI to hand it over, but on the way, you get pulled over. And through a series of bizarre events, you find yourself locked in an incredibly intense, high-stakes battle in traffic court over a contested left turn.
Right.
Now, this isn't a fake traffic ticket. Maybe you really did run the red light. Maybe you didn't. You hire the best lawyers. You spend a year fighting the city over the calibration of the traffic camera, the intersection angles, the timing of the yellow light.
And you might even win the traffic case.
You might win, but it doesn't matter. Because for that entire year, the bank robbery footage is just sitting in the truck.
Unseen.
Exactly. You are physically in the wrong building, standing in front of the wrong municipal judge, operating under the wrong set of traffic codes to ever pull out a hard drive and say, hey, look at this bank robbery.
That's the perfect way to explain it.
The trap isn't about whether you win or lose the left turn dispute in Virginia. It's about forcing you to spend all your resources in a courtroom that physically and legally cannot hear the evidence you actually want to present.
That analogy perfectly isolates the structural problem.
Mm-hmm.
The author is stressing that the choreography of this trap is completely indifferent to the outcome of the Virginia case.
They don't care who wins.
The opposition does not care if the conservative legal apparatus wins the Virginia redistricting fight or loses it.
Mm.
The choreography is simply keep them busy.
Wow.
For the next 12 months, every high-level officer of the court who might otherwise be engaged in election integrity forensics is fighting a demographic battle. And whichever way that battle resolves, the underlying evidentiary record from 2020 remains exactly where it has been for 5 years, preserved, unexamined, and structurally silenced.
That makes terrifying sense. It's basically a war of attrition, but focused purely on attention and bandwidth.
Yes, exactly.
But this raises a massive chronological question, I think.
Which is,
if this trap is currently active to keep people away from the evidence, where is the evidence? Where did this whole strategy of silencing forensic records actually begin? Because the author doesn't just talk about Virginia. They point us back to a very specific origin point.
yes, they do. To understand why the evidence is locked away, we really have to understand the specific legal weapon used to lock it.
Okay.
The briefing transitions into an incredibly granular breakdown of a case out of the U.S. District Court for the District of Colorado.
This is the 5-year arc of Peters v. Feyen. The case began with forensic imaging in 2021. A conviction followed, but the sentence was vacated. Today, a habeas petition is filed, but the evidence remains unseen.
The timeline covers key milestones: forensic imaging authorized, custodial intent excluded, a conviction in 20...
The case is Peters v. Feyen.
Okay. Peters v. Feyen.
The author identifies this specific trial as the genesis, the anchor point of what they call the prosecutorial doctrine.
Let's set the stage for this, because this case is kind of the linchpin for the rest of the document.
It really is.
The year is 2021. The individual at the center of this is Tina Peters. At the time, she was the elected clerk and recorder of Mesa County, Colorado.
And we need to define what that title actually means legally. Because a county clerk is not just an administrator.
Right, they aren't just filing papers.
They are the sworn legal custodian of the county's records. They have statutory duties. State election law, not just in Colorado but across the country, imposes very strict affirmative obligations on these local officials to preserve election records for specific periods.
Usually like 22 months under federal law, right?
Often 22 months under federal law, yes, but state laws vary.
Okay, so she isn't just some random citizen. She is the person legally on the hook if records go missing.
Ex-
Now, according to the document, Peters believed, and she maintains to this day, that her statutory preservation obligations required her to capture a forensic image of the county's voting system data. She decided to do this right before a scheduled procedure known as a trusted build.
We need to unpack what a trusted build is mechanically, because it is central to why she felt an affirmative duty to act.
Yeah, let's get into the tech a bit.
A trusted build is not just a simple software update, like, updating an app on your phone.
Yeah.
In the context of voting systems, a trusted build is a comprehensive installation of certified software and firmware provided by the state and the vendor.
Right, so it's essentially wiping the slate clean and installing a fresh, state-approved operating system onto the voting machines.
Exactly. It re-images the hard drives, it overwrites partition data, it replaces system files, and crucially, it wipes event logs and forensic artifacts that existed on the machine prior to the build.
Oh, wow. So the history is just gone.
Yes. From a purely technical forensic standpoint, executing a trusted build destroys the prior state of the machine.
That's huge.
It is. If you are a custodian of records and your legal duty is to preserve the exact state of the election data as it existed during the election, allowing a trusted build to overwrite that data without first taking a bit-for-bit forensic image is arguably a destruction of records.
So she looks at the law, she looks at the impending trusted build, and she concludes, hey, if I don't image this drive right now, the evidence of the 2020 election is going to be digitally paved over.
Right.
She authorizes the imaging, the forensic images are created, the data is preserved.
And then the apparatus responds.
And how?
The chain of custody ensures digital evidence is preserved. Legal custodians capture records before they can be altered. Forensic imaging and write blockers maintain bit-for-bit integrity. The material is sealed and neutral tribunal has reviewed it.
And then the apparatus responds.
And how?
The state of Colorado prosecutes her for that specific action. They charge her with multiple felonies and misdemeanors related to attempting to influence a public servant, identity theft, and official misconduct.
Just a barrage of charges.
All stemming from the process she used to get the forensic experts access to the machines to create the image.
And this is where we hit what the author describes as the great trial paradox. This part of the briefing is staggering to read.
It really is.
The author, who explicitly notes they are serving as the lead amici curiae, or friend of the court, in the current federal proceedings for this case, they break down exactly how the prosecution structured their attack at trial.
State election laws across the country impose a specific statutory duty on local officials. They must preserve the records of every election. In 2021, Tina Peters was the elected clerk and recorder of Mesa County, Colorado. In that role, she was the primary legal custodian of the county's voting system data. When a trusted build update was scheduled to modify the county's software, Peters authorized a forensic image of the equipment. She believed this was necessary to capture the underlying record before the update altered it. While the forensic images were successfully created and the data preserved, the state of Colorado moved to prosecute Peters for that specific act. This prosecution treated an act of statutory preservation as a criminal offense, creating a procedural contradiction that would define the entire legal battle. Despite the multi-year prosecution that followed, the actual forensic evidence Peters preserved was never introduced or examined during her trial. 5 years later, no court or neutral tribunal has ruled on the merits of the Mesa County data or evaluated its substantive content. This vacuum exists because the legal proceedings were structured to adjudicate whether Peters had the authority to look at the data, not whether the data she found was accurate. By criminalizing the custodian for the act of preservation, the legal system ensured the evidence itself remained silenced and unadjudicated. During the criminal trial, the prosecution had to secure a conviction against an official who maintained she was simply performing her job. The prosecution's theory, accepted by the court, was that Peters' belief in her duty was legally irrelevant. The judge excluded her intent from the trial's merits. Her defense, acting as a custodian, was removed from the scales entirely. With intent ruled out of bounds, the court never had to litigate the complex question of whether a county clerk possesses the authority to capture forensic images under state election law. This framework led directly to Peters being convicted on 4 felony and 3 misdemeanor counts based solely on her physical actions. The conviction was achieved by decoupling the defendant's actions from the legal context she claimed authorized them. The structure of the case shifted once the trial moved to the sentencing phase. The same court that had previously ruled Peter's intent was irrelevant reversed its posture and reintroduced her beliefs into the record. The judge used those beliefs as justification for a harsher penalty, explicitly punishing her for the conviction that she was fulfilling a preservation duty. The court's official record labeled her a charlatan and dismissed her forensic preservation efforts as snake oil. On the basis of that characterization, the court sentenced Peters to 9 years in state prison, a sentence driven by the same intent that had been excluded from the trial itself. This is the operative model. Exclude intent to secure the conviction, then weaponize it at sentencing to delegitimize the evidence the defendant preserved. When a custodian is criminalized before their evidence can be rebutted, the forensic material they hold is effectively silenced. This pattern extends beyond Colorado to preserved 2020 election server images from Pennsylvania. This Pennsylvania material was captured under the same principle used in Mesa County, that a custodian has a duty to image the record before mandated procedures alter the data. Like the Mesa County images, this evidence remains unadjudicated and functionally excluded from public discourse, while the Peters precedent stands. The doctrine creates a structural trap where no court is required to examine preserved forensic material as long as the person who preserved it faces prosecution. This legal architecture reached a turning point on April 2, 2026, when the Colorado Court of Appeals vacated Peters' sentence. The appellate court found that the trial judge violated the First Amendment by basing the 9-year sentence on Peters' speech and beliefs. The case has now transitioned into a federal habeas corpus petition, Peters v. Feyen, in the U.S. District Court for the District of Colorado. This federal review will determine if the procedural wall built between the trial and sentencing phases can survive constitutional scrutiny. The outcome of this docket establishes whether the justice system can continue to adjudicate the conduct of election custodians while remaining blind to the evidence they preserved.
And then the apparatus responds.
And how?
The state of Colorado prosecutes her for that specific action. They charge her with multiple felonies and misdemeanors related to attempting to influence a public servant, identity theft, and official misconduct.
Just a barrage of charges.
All stemming from the process she used to get the forensic experts access to the machines to create the image.
And this is where we hit what the author describes as the great trial paradox. This part of the briefing is staggering to read.
It really is.
The author, who explicitly notes they are serving as the lead amici curiae, or friend of the court, in the current federal proceedings for this case, they break down exactly how the prosecution structured their attack at trial.
The author details that the prosecution presented a theory to the trial court that was both brilliant and structurally devastating.
Devastating how?
The prosecution argued that Peters' intent was legally irrelevant to the charges.
Okay, I have to stop you there and play devil's advocate for a second. To be fair to the trial court, isn't that just how strict liability works?
Wow.
I mean, if I am speeding in a school zone because I'm late for work, my intent doesn't matter. I still broke the speed limit. The law doesn't care why I was speeding. Why should a local clerk be treated any differently?
That is a very common assumption, but it conflates two completely different areas of law. Speeding is a strict liability offense. You commit the act, you are guilty.
Right.
But most criminal law, especially felonies involving official misconduct or fraud, requires two elements: the actus reus, which is the guilty act, and the mens rea, which is the guilty mind.
The intent to commit a crime.
Precisely. Think about it like this. If you accidentally walk out of a store with a candy bar you forgot to pay for, you committed the act of taking it, but you lacked the intent to steal.
So it's not theft.
Therefore, it's not theft. In the context of a public official acting under color of law, intent is everything. The substantive question is, did she act with criminal malice, or did she act under a genuine, even if mistaken, belief that state law legally required her to preserve this data?
So if she genuinely believed she was executing a statutory duty, the mens rea for criminal misconduct doesn't actually exist.
Exactly. But the author notes that the trial court accepted the prosecution's theory and excluded her intent.
Wow.
Let that sink in. The jury was not allowed to weigh whether she thought she was doing her job. The court ruled that her belief in her own statutory authority did not matter when determining if her conduct met the elements of the crime.
That is wild.
She was judged solely on the mechanical actions she took to get the machines imaged, completely divorced from the legal duties she believed she was executing.
So the jury basically has their hands tied. They aren't looking at a clerk trying to save data. They are just looking at a woman who circumvented security protocols.
Right.
Based on those actions alone, she is convicted on 4 felony counts and 3 misdemeanor counts.
That's right.
But then we get to sentencing, and this is where the logic of the legal system seems to completely break down.
It is a profound structural paradox, because at sentencing, the entire posture of the trial court completely reverses.
How so? Like, what happened?
During the trial, the judge explicitly ruled that her intent, her belief, and her legal duties was completely irrelevant.
Right, couldn't bring it up.
But at sentencing, the judge suddenly reintroduces her intent. And not just as a footnote, the judge weighs it incredibly heavily against her.
Are you kidding me?
No. The court characterizes her beliefs about her statutory obligations as pretextual, as malicious, as conspiratorial. The judge publicly brands her a charlatan.
Oh, wow.
The judge refers to her preservation efforts as selling snake oil.
Wait. You cannot have it both ways.
You really shouldn't be able to.
You cannot legally forbid a defendant from explaining their intent to the jury to prove their innocence, and then the moment the jury leaves the room, use that exact same intent to maximize their punishment. It's like heads the state wins, tails the defendant loses.
It violates foundational concepts of evidentiary fairness, and it heavily prejudiced the outcome. Based largely on this characterization of her intent, and intent she was procedurally forbidden from defending as a legal duty, during the trial, the judge sentences her to 9 years in state prison.
9 years.
9 years for preserving data she believes she was legally required to preserve.
That is absolutely insane. Did any higher court step in? Because that sounds like a massive oversight.
Yes. The briefing notes that on April 2, 2026, the Colorado Court of Appeals actually intervened. They vacated that 9-year sentence.
Okay, on what grounds?
On First Amendment grounds. The appellate court found that the trial judge had improperly considered Peters' protected speech and political beliefs during the sentencing phase.
So the appellate court recognized the paradox.
They recognized a constitutional violation at sentencing, yes. Which brings the case to its current posture. The author notes the case has moved into a federal habeas corpus petition in the U.S. District Court for the District of Colorado.
Okay, let's define habeas corpus for a second, just so everyone is on the same page. This isn't just an appeal, right?
No, it's very different. A direct appeal argues that the trial court made a procedural mistake based on the existing record. A writ of habeas corpus is a fundamental constitutional mechanism.
Right.
It is a civil action against the state, usually brought in federal court, arguing that a state prisoner is being held in violation of the U.S. Constitution or federal law.
Got it.
It allows a federal judge to step in and say, the way this state conducted this trial violated this person's fundamental civil rights. The author is actually leading an amicus brief in this federal habeas proceeding with over 3,000 co-signatories.
3,000? Wow.
Yeah, arguing that the exclusion of intent at trial fundamentally deprived her of a defense.
Okay, so that is the anchor case. That is the timeline of Tina Peters. But the author's primary goal in this document isn't just to relitigate Colorado, is it?
No.
The author takes the mechanics of the specific trial and extracts a broader theory. They argue that what happened to Peters isn't an isolated anomaly. It is a replicable, highly engineered legal weapon.
The author defines this as the prosecutorial doctrine.
The prosecutorial doctrine.
Right. It is a 3-step mechanism designed to achieve a very specific outcome: silencing preserved forensic evidence without ever having to actually debate the evidence itself. It destroys the evidence by destroying the custodian.
Let's walk through the 3 steps of this doctrine, because this is fascinating. Step 1.
Step 1. Criminalize the act of preservation. You convert an act of statutory preservation into a crime by treating the official's belief in their own authority as legally irrelevant.
You bypass the substantive debate entirely.
Exactly. The question, did this clerk actually have the legal authority under state law to image this drive? That is never adjudicated. It is ruled out of bounds as a matter of evidentiary structure before it can even be asked.
Which is such a brilliant, if terrifying, legal maneuver. Because if you actually litigate her authority, you might lose, right?
That's the risk.
State laws on election records are notoriously vague. If a court formally rules that, yes, local clerks actually do have the authority to image these drives, the entire system falls apart.
Right.
By criminalizing the act of bypass right out of the gate, you never have to risk a judge setting a precedent that clerks are allowed to do this.
Precisely. You skip the legal philosophy and go straight to the criminal code. That leads directly to step 2, weaponize character.
This is the sentencing phase.
Yes. In sentencing, the rules of evidence are relaxed. The judge has broad discretion to consider character, background and motives. The doctrine utilizes this phase to publicly destroy the custodian.
Right, calling them a charlatan.
Exactly. By having an authority figure, a judge in a black robe, formally label the custodian a charlatan and their actions snake oil, the apparatus is generating official court transcripts.
Transcripts that are instantly turned into headlines.
Exactly. The goal is to set a permanent public narrative designed specifically for media consumption. You are retroactively delegitimizing the evidence she preserved by destroying the character of the person who preserved it.
Wow.
And you do this without a single forensic expert ever looking at the hard drives.
Which executes step 3, silence by association.
The silencing is achieved entirely without engagement. Because the person who preserved the evidence is now a convicted felon, legally branded a charlatan who sells snake oil, the data itself is permanently tainted by association.
It's toxic.
Very. Anyone who steps forward a year later and says, hey, maybe we should look at those forensic images from Mesa County, is instantly associated with the snake oil. They are discredited before they finish their sentence.
So think about the real-world implications of this. Think about the chilling effect. Imagine you are a local IT director or a newly elected county clerk in a completely different state.
Okay.
You are digging through some servers and you see something anomalous, something weird in the partition tables from the last election.
Right.
You know you have a statutory duty to preserve records, but you also just watched what happened to Tina Peters in Colorado. You watched her get handed a 9-year prison sentence for trying to preserve data, and you watched the court refuse to even let her explain her intent.
Are you going to stick your neck out?
Absolutely not. You are terrified. You are completely paralyzed. The capacity of investigative teams at the local level immediately drops to 0.
Of course it does.
No one is going to preserve anything outside of the strictly mandated top-down vendor protocols because the structural threat of parallel prosecution is just too massive. You don't want to be the next Tina Peters.
And that structural paralysis is the perfect segue into the next major section of the briefing, because the author shows us exactly what happens to data that is caught in this chilling effect. We moved from Colorado to Pennsylvania.
The Pennsylvania material. The author brings up forensic images of Pennsylvania election system servers from the 2020 cycle, and they use a very deliberate, specific phrase here. They say the Pennsylvania material is not analogous to the Colorado material, it is parallel.
That distinction is vital for a legal analysis.
Oh, so?
If it were merely analogous, it would just be similar. Calling it parallel means it exists on the exact same legal and timeline trajectory. The author states that the Pennsylvania data was preserved under the exact same legal premise as the Mesa County data.
Right.
The belief by custodians that a statutory duty required the capture of the record before mandated procedures altered the underlying data.
So someone in Pennsylvania essentially did exactly what Tina Peters did. They saw an update coming, and they took an image first.
Yes. The source states unequivocally that this Pennsylvania material exists, that it was successfully preserved, and that it currently resides in a preserved state.
But just like the Colorado data, it is sitting in an absolute evidentiary blackout.
Total blackout. The author notes that this material has never been contested in any court proceeding. It has never been reviewed by any tribunal on the merits.
Not even looked at.
Never. It has never been subjected to cross-examination or rebuttal or a neutral evidentiary protocol where both sides get to look at the hash values. It is just sitting in a digital vault.
So the obvious question you, the listener, are probably asking right now is, if this data exists, and if people care so passionately about election integrity, why hasn't someone just brought it to a judge? Why is it locked in the vault?
Well, because of the prosecutorial doctrine we just defined, this is where the trap and the doctrine merge.
Okay, connect those dots for us.
The Pennsylvania material is functionally silenced because the overarching legal apparatus ignores it. And they can afford to ignore it because the structural threat established in Colorado prevents anyone from forcing the issue.
Right.
If you are the custodian holding that Pennsylvania data, you look at the Peters case and you realize that trying to bring this evidence into the light might result in your intent being excluded at trial, weaponized at sentencing, and you ending up in prison.
The apparatus relies entirely on that fear. It doesn't need to destroy the data. It just needs to make it impossibly dangerous to talk about it.
Exactly.
And I think we need to pause here and emphasize a major clarification the author makes in the text. This is crucial for maintaining our objective analysis.
Yes, the author is very explicit about what they are not claiming regarding the Pennsylvania material.
Right. The author explicitly states that they are not claiming in this briefing that the Pennsylvania material proves any specific anomaly about the 2020 election. They are not claiming it as a smoking gun of fraud.
Exactly. What they are claiming, and what they state is verifiable on the existing legal record, is simply that the material exists.
That it's there.
It was preserved under recognized principles of custodial duty, and it has never been examined. The structural reason for that lack of examination is the threat of the prosecutorial doctrine.
So the truth is just hidden.
Right. What is actually in the material is a question for adjudication. But that adjudication has been procedurally prevented from ever occurring.
We are back to the vault analogy. We have lawyers spending millions of dollars arguing about the zoning laws of the building in Virginia. Meanwhile, the vault in Pennsylvania sits there.
Just waiting.
No one is saying the vault contains solid gold, and no one is saying it's completely empty. The author is simply pointing out that there are heavily armed procedural guards standing in front of the door, threatening to imprison anyone who asks for the combination.
It is a profound observation about the mechanics of evidence suppression. But the author doesn't limit their analysis to just courtrooms and legal doctrines.
Right, they pivot.
They pivot in the next section to the operational and technological layers of this conflict, because a legal trap of this magnitude requires a massive coalition to maintain it. And the author points out that this coalition is starting to leave operational tells.
This is where the briefing reads like a spy novel, honestly. The author introduces something they call the Schiller question.
The Schiller question, yes.
This involves whistleblower allegations made by a man named Tom Schiller. Now, the author lists some massive entities involved in these allegations: Microsoft, the Department of Defense, Azure Cloud Computing Environments, and the alleged use of China-based engineers for sensitive infrastructure.
The author is careful to note that the deep substance of those specific whistleblower allegations will be covered in future installments. However, they extract a very specific, highly technical behavioral observation from how the coalition is reacting to these allegations right now.
The technical asymmetry.
Yes. The briefing indicates that figures within this coalition, specifically figures with backgrounds in signals collection and intelligence community tradecraft, they're exhibiting a very specific pattern of behavior regarding cybersecurity.
What are they doing?
They are actively downplaying concerns about endpoint vulnerabilities, while intensely focusing the coalition's attention on transport layer security.
Okay, we need to break this down. The author makes it clear that understanding this distinction is the key to seeing the panic inside the coalition. Transport layer security versus endpoint security. Let's start with transport layer.
Let's look at it mechanistically. A transport layer attack is an interception attack. It happens while data is in transit.
Okay.
When you send a message from your phone to a server, or from one database to another, the data travels across networks, routers, and cables. A transport layer attack, often called a man-in-the-middle attack, involves someone tapping that line and reading the data as it flows.
But this is a known problem, right? We have defenses for this.
We have excellent defenses. This is why we use TLS, transport layer security, and end-to-end encryption. The data is scrambled before it leaves your device, and it stays scrambled until it reaches the destination.
So even if they tap the line, it's useless.
Exactly. If someone taps the line, all they get is cryptographic gibberish. The author notes that transport layer security is a well-understood, well-defended class of threat.
Right. Now, contrast that with the endpoint.
The endpoint is the physical device itself.
Yeah.
Your smartphone, your laptop, the literal server sitting in the rack at the data center. Endpoint compromise means the device itself has been fundamentally breached.
So they are inside the house.
Exactly. An adversary has established a backdoor into your operating system. They have a rootkit installed. They have a keylogger capturing your keystrokes. Or, most simply, they are using malware to literally take screenshots of your display while you're looking at it.
So let me expand on an analogy here to make this really clear. Imagine you have a highly classified document you need to send from Washington, D.C. to New York. You put that document inside a massively armored convoy. You have tanks, helicopters, bulletproof glass, and armed guards surrounding the truck. That is your transport layer security. No one is going to intercept that truck on the I-95. The data in transit is perfectly secure.
It is impenetrable.
But if you are so obsessed with the armor on the truck that you completely ignore the fact that the guy driving the truck, the endpoint, has already been compromised and is working for the enemy, well, all that armor is worthless.
Because the driver has the document.
Exactly. The driver doesn't need to break into the armored box on the highway. He just pulls out his phone and takes a picture of the document before he puts it in the lockbox.
Exactly. If the endpoint is compromised, transport layer security is completely irrelevant. The data is stolen before encryption occurs or after decryption happens.
Wow.
And the author points out that for intelligence actors who rely on plausible deniability, endpoint compromise is a massive, highly sensitive problem. It is much harder to detect and much harder to clean up.
Which brings us to the operational tell. The author highlights a specific technological migration this coalition is currently executing. The briefing notes that the coalition is panicking and migrating its internal communications off a platform called Matrix and moving everyone onto Signal.
Now, everyone knows Signal. It is widely considered the gold standard for secure consumer messaging.
Because it has incredible end-to-end encryption.
Which is transport layer security.
Ah.
Signal is fantastic at making sure no one intercepts your message while it travels through the cell towers.
Okay.
But, as the author astutely points out, if you are migrating platforms because you are terrified of endpoint compromise if you suspect your physical phones are bugged, or you suspect insider collection at the OS level, moving to Signal does absolutely nothing.
Because if someone has a screen scraper malware on your iPhone, they just read the Signal messages right off your screen while the app is open. The encryption never even factors into it.
Precisely. Signal encrypts the data after you type it and decrypts it before you read it. If the OS itself is hostile, Signal is blind to the theft.
So moving to Signal is just security theater at that point.
Exactly. Therefore, a panicked migration to Signal only makes logical sense if you're exclusively worried about interception in transit. It's the completely wrong solution for a compromised device.
So why are they doing it? What does this tell us?
The conclusion the author draws is chilling. We have intelligence figures telling the coalition not to get too hung up on endpoint vulnerabilities, actively downplaying the threat of device compromise. But simultaneously, the whole coalition is panicking and migrating to Signal to tighten communications.
It's a huge red flag.
This is massive operational tell.
It means they know someone is watching them.
It means that at the senior levels of this operation, there is acute concern about communications integrity. They are trying to enforce operational discipline on a very compressed timeline.
Rushing to plug holes.
The author suggests two possibilities. Either senior leadership knows endpoint compromise is a massive vulnerability that they desperately want to hide from their own lower-level members, or even more concerning, endpoint compromise is actually operationally expected.
Meaning they planned for it?
It is baked into their intelligence model, and they are using the Signal migration as a placebo to calm the troops down. Either way, they are preparing for intense adversarial scrutiny. They are rushing to patch holes, even if they are patching the wrong ones.
Wow. Okay, so let's review the board for a second. We have a highly engineered jurisdictional trap in Virginia designed to consume capacity. We have a prosecutorial doctrine born in Colorado designed to silence custodians.
Right.
We have unexamined parallel evidence sitting in a blackout in Pennsylvania. And we have a coalition showing signs of massive technological panic rushing to migrate comms.
That's the setup.
All of this builds to the absolute climax of the document, which is the procedural strategy to break the trap. The author is adamant that you cannot tweet your way out of this. You cannot go on cable news and yell about it. You need a highly disciplined, surgical legal maneuver.
The briefing outlines 5 specific rules or indicators that allied officials must adhere to if they want to survive this architecture.
Okay, let's hear them.
First, maintain a multi-jurisdictional lens.
Meaning, stop looking at these cases in a vacuum.
Yes, you cannot just fight Virginia in Virginia. You have to see how Colorado's prosecutorial doctrine, Pennsylvania's silence data, and Virginia's capacity consumption are structurally connected.
Makes sense. What's the second rule?
Second, execute a disciplined response. There could be no fragmented camps, no infighting among allied legal teams trying to grab the spotlight.
Everyone has to be on the same page.
Exactly. Third, accept no pre-scripted framing. Do not let the opposition or even the click-driven media ecosystem on your own side dictate the terms of the legal argument.
Stay on the procedural mechanics.
Fourth, use vetted grassroots operations. The people supporting the effort on the ground must be disciplined, authenticated, and immune to provocateurs.
Very important.
And fifth, document the choreography in real time. Keep an immaculate time-stamped record of how the opposition maneuvers their assets.
But these are just guiding principles, right? The core of the strategy, the actual weapon to break the trap, comes down to establishing legal standing because, as we discussed an hour ago, you cannot fight this battle in the Virginia redistricting courtroom.
Correct. The Virginia judge has no jurisdiction. Therefore, the author explains that allied legal teams must construct a completely new procedural framework. They must physically build the courtroom that can hear the case.
How exactly do you do that? What is the mechanism of legal standing?
Article 3, standing in federal court requires 3 things: injury, in fact, causation, and redressability. You have to prove you suffered a concrete harm, you have to prove the defendant caused it, and you have to prove the court can actually fix it.
So how does an attorney general legally connect a redistricting map in Virginia to a forensic server image in Pennsylvania?
You don't argue the facts of Pennsylvania and Virginia. You argue the procedural suppression.
Ah.
The strategy requires coordinating what the author calls cross-jurisdictional evidence filings. You have to show a federal judge that the Virginia litigation is fundamentally intertwined with a broader pattern of evidentiary suppression.
Right.
You argue that the capacity consumption in Virginia is causing an ongoing injury, in fact, by preventing state AGs from investigating the parallel data in Pennsylvania and Colorado.
So you ask the federal judge to step in and say, wait, before we spend a year on this Virginia map, we need to address this massive multi-state suppression of discovery that is preventing these AGs from doing their jobs.
Exactly. You ask for an injunction or a stay of proceedings based on the broader constitutional implications. You build a procedural bridge that links the cases, forcing the hidden evidence out of the blackout.
This is an incredibly brilliant, highly technical legal strategy. And here is where the document gets truly wild. The author explains the necessity of the strategy. The author explains the necessity of the strategy and then explicitly refuses to write down the actual step-by-step instructions in the briefing.
The actual legal roadmap is missing.
It's just not there.
It is missing by design. It is a masterclass in operational security. The author states that the private briefing memorandum, the document containing the precise legal filings, the exact jurisdictions to target, the specific precedents to cite, the draft injunctions, that document is strictly not for public consumption.
Because if you publish the playbook online, the opposition just reads it and builds a counter strategy.
If it goes public, the opposing legal apparatus will instantly file procedural countermeasures to block the standing arguments before they're even made. The entire strategy relies 100% on the element of surprise.
Makes total sense.
Therefore, the briefing mandates a very specific method of delivery for this private memorandum. It requires direct hand-to-hand delivery.
Physical delivery.
Yes. It must be physically handed to state attorneys general, specific DOJ professionals, and the Peters legal team via trusted, known intermediaries.
Which ties perfectly back into the whole cybersecurity section we just dissected. Think about it.
It does.
If you email this highly sensitive legal strategy to an AG, or if you put it in a secure Signal group chat, and we just established that endpoint compromise is a massive, highly expected vulnerability, well, the opposition's malware reads the PDF on the AG's phone before the AG even opens the file.
Exactly. The digital environment is completely hostile. Hand-to-hand delivery bypasses the entire digital infrastructure. It renders transport layer encryption debates and endpoint rootkits completely irrelevant.
Right, if it's on paper.
If it never touches a network, it cannot be intercepted.
It is the ultimate analog solution to an inescapable digital surveillance problem.
And the author notes that this is how serious, high-stakes legal and political coordination has operated since the founding of the Republic. You meet in person, you use known intermediaries you trust with your life, and you maintain absolute operational discretion.
But there is a massive problem with analog delivery. It is slow. And this brings us to the final, incredibly tense section of the document, the Mayday timeline. There is a ticking clock attached to this entire operation.
The author lays out a chronological sequence of events that is barreling toward a very specific, immovable deadline. We have tracked the origin of the doctrine in the 2021 Peters case. We have observed the ongoing evidentiary blackout in Pennsylvania.
Right.
We have analyzed the panic technological migrations happening right now, and all of this choreography is leading up to a massive deployment date referred to as Mayday.
Based on the dating of the document, the author states that Mayday is exactly 7 days away.
Yes. The context strongly implies that the kickoff for this massive coordinated deployment is May 1st.
What exactly is happening on Mayday? Like, what does the launch look like?
The briefing suggests that this deployment is staggered across all affinity groups within the opposition coalition. This implies a highly coordinated, multifaceted launch of legal, political, and potentially media operations.
So it's not all at once.
Right. The author compares the structure of this impending launch to previous rehearsal cycles, specifically citing the No Kings deployments and historical BLM operational models.
Meaning they roll it out in waves. It's not just one press release, it's a staggered, compounding series of actions designed to overwhelm the system. It has been practiced, it has been stress-tested, and the kickoff is May 1st.
That's the assessment.
So what are the procedural milestones for the Allied officials reading this briefing? What do the AGs and the legal teams have to do in the next 7 days?
The directive is absolute. Officials must finalize and file their cross-jurisdictional procedural filings before the Mayday deadline.
For the kickoff.
They must precede the deployment. The author emphasizes that the window for action is open right now, but it is closing rapidly. If legal teams wait until after Mayday launches, if they wait for the opposition to make the first move, they will be forced into a purely reactionary posture. They will be playing defense against a fully deployed, highly resourced operation.
The move that breaks the choreography is one that has to be made before the choreography finishes running.
Exactly. You cannot disrupt a machine once it has reached full operational speed. You have to jam the gears while it's still spinning up.
Wow. If we pull back and look at everything we've unpacked today, the Virginia trap, the Colorado doctrine, the Pennsylvania blackout, the technical panic, the hand-to-hand strategy, what is the core lesson here?
The core takeaway from this source material is a profound lesson in how power actually operates within the modern legal system. Understanding this briefing means realizing that the most consequential legal battles in our society are rarely the passionate arguments happening in front of the judge on camera.
The stuff we see on TV?
Right. The real war is fought over the invisible procedural fences being built behind the scenes. It is fought over jurisdiction, over standing, and over the structural suppression of discovery.
The hidden architecture.
Exactly. The opposition doesn't win by proving their evidence is better. They win by ensuring your evidence is never allowed in the building.
It really is a masterclass in critical thinking for anyone trying to navigate the sheer volume of information we deal with today. We are so trained to look at the headlines, right? We are trained to argue about the verdict or the judge's final ruling.
We all fall for it.
But this document is screaming at us to look at the structure beneath the ruling. Look at what is not allowed to be said in court. Look at the specific questions that are ruled legally out of bounds before they can even be asked by a lawyer.
It requires a fundamental shift in perspective. You have to look past the distraction of the real fight to see how that very real fight is being leveraged as a tool to consume your capacity to investigate anything else.
Yeah. So I want to leave you, the listener, with a final thought to mull over, a question that really lingered with me after digesting the sheer scale of the architecture described in this briefing.
It's a lot to process.
It really is. We just spent an hour mapping out a highly credible, meticulously documented theory about how procedural maneuvers and jurisdictional mismatches can effectively lock away massive caches of forensic data for half a decade without a single neutral party ever opening the box or looking at a hard drive.
Right.
If a legal apparatus is sophisticated enough to build a structural trap that silences election data simply by criminalizing the custodian, well, what else is in the vault?
It is a staggering question to consider.
What other historical records, what other scientific data, what other crucial foundational truths in our society are currently sitting in some digital purgatory, completely unexamined, simply waiting for the right jurisdiction to finally be looked at? How much of our reality is shaped not by the evidence we see, but by the evidence we are procedurally forbidden from examining?
Remember the vault. They will spend 5 years arguing passionately about the zoning laws of the building, precisely so you never have the time to ask for the combination to the lock.
Exactly. It's not the story they tell you that is important. It's what they omit.
Thanks for joining us on this deep dive. We'll catch you on the next one. The Virginia redistricting fight, on its own merits, is a real fight. So that is the exact opening line of a document we are looking at today. It's a document that basically claims to expose a massive invisible trap operating right now inside the American legal system.
Yeah, and it's an incredibly bold premise right out of the gate.
It really is, because today we are going to look at how a single 9-year prison sentence out in Colorado might be the absolute linchpin to silencing digital election evidence nationwide.
Right.
And we're going to explore how an entire multi-million-dollar legal war on the East Coast might just be, a manufactured decoy, just to keep anyone from looking too closely at that silenced evidence.
And going back to that quote, what is really striking about it is that it just grants the opposing side's constitutional question immediately.
Yeah, totally.
I mean, in modern legal and political discourse, especially when you're talking about election integrity, granting the premise of your opponent is almost jarring to read. It disarms you. It kind of forces you to look at the mechanics of the argument rather than, just the politics of the author.
Exactly. So to you listening right now, welcome to our deep dive. We've got a really fascinating piece of source material today. We are looking at a document. It's titled Fulcrum 2.pdf, authored by someone writing under the pseudonym Tor.
Right, Tor.
And before we even touch the first actual argument in this text, we really need to establish the rules of engagement for this conversation.
Oh, absolutely. That is crucial here.
Because, this document sits squarely in the middle of a highly polarized, deeply contested space, right? The American rights election integrity movement. And the instinct for a lot of people, and definitely for the broader media ecosystem, is to just immediately sort this kind of document into a bucket.
Yeah, you look at the author, you judge the politics, you slap a label on it, and you move on without even reading the actual text.
Right. But that completely defeats the purpose of analysis.
Hmm.
You and I, and you listening at home, we are not here today to be advocates for this text.
No.
Nor are we here to be like partisan critics. We are going to treat this document as a people's brief filed in the court of public discourse.
Right. A people's brief? I like that framing.
And our mission is to answer a very specific set of questions. What is this document actually arguing at a structural level? And if we just step inside the architecture of the author's logic, does it hold up on its own terms?
Yeah, and my background is in constitutional law, specifically First Amendment doctrine and federal habeas practice, so I tend to look at the skeletal structure of how laws are applied.
Right, and I spent years as a courtroom reporter covering election law procedure. So my default setting is just skepticism. I'm skeptical of the prosecution, I'm skeptical of the defense, and I'm highly skeptical of my own framing.
Which is exactly what we need for this, because our method today has to be incredibly strict. We are going to separate the author's claims from verifiable facts. We have to identify what is actually written on the public record versus what is a structural inference being made by the author.
Yeah, and if we are really going to test the structural integrity of this brief, we have to rigorously steelman it.
Yes, absolutely.
We have to build up the absolute strongest, most coherent version of the author's argument. But equally, we had to build up the strongest, credible counterarguments against it. We are not looking at political outcomes today. We are looking at the invisible architecture of how the legal system processes information.
Or, more importantly, how it structurally refuses to process certain information.
Exactly. Okay, let's unpack this, because we actually can't start where the breeze starts.
No, we have to go out west.
Right. The author makes this really compelling case that to understand the trap being set in Virginia right now, you have to look at the anatomy of an anchor case in Colorado. We are talking about Peters v. Feyen.
Civil action number 1.25 CV 00425 in the U.S. District Court for the District of Colorado.
Right. That is the cornerstone of the entire document.
Everything else the author argues relies on understanding the specific doctrinal mechanism that was deployed in that specific courtroom.
So let's lay out the plain language facts of this case.
Right.
And we are relying strictly on the verifiable public record here. We are rewinding to 2021.
Okay, 2021.
Tina Peters is the elected clerk and recorder of Mesa County, Colorado.
Sure.
In that specific capacity, by state law, she is the legal custodian of the county's voting system records.
Right.
And Colorado election law, like essentially every other jurisdiction in the country, imposes incredibly strict preservation obligations on local election officials.
Yeah, you are legally mandated to keep the records intact. It is not a suggestion. It is a fundamental statutory duty of the office she holds. You are the steward of the public record.
Exactly. So we have a situation where Peters believed, and she has maintained this belief consistently, by the way, that her preservation obligations required her to capture a forensic image of the county's voting system data.
And she wanted to do this specifically before a scheduled procedure known as a trusted build took place.
Right. Now let's pause and make sure we understand the technical reality of that.
Yeah.
Because for anyone who doesn't work in IT or software engineering, a trusted build in this context is essentially a massive system update.
Right. It's mandated by the state.
Mandated by the state, designed to patch vulnerabilities, update software, and standardize all the machines. But By definition, when you run an update of that magnitude, it modifies the underlying data.
Oh, absolutely. It overwrites logs. It completely changes the digital landscape of the hard drive.
Yeah. From a purely technical standpoint, running a trusted build destroys the previous state of the machine.
So if you need to know exactly what the digital environment looked like during the prior election, that environment is just gone once the trusted build is executed.
Gone. Poof. So Peters, acting as a custodian, authorizes the forensic imaging. And to be clear, a forensic image is not just, dragging and dropping some files onto a thumb drive.
Yeah.
It is a bit-by-bit exact replica of the entire digital environment. That include deleted files, unallocated space, system logs, everything.
It's the whole universe of that machine.
Right. The forensic images are created. The evidence of the system's exact state at that specific moment in time is preserved. And that single act of preservation triggers an absolute legal earthquake.
Because the state of Colorado did not view that as a legitimate custodial action. They viewed it as a severe breach of protocol and, frankly, a criminal act.
Right. She is prosecuted by the state. She's indicted. She goes to trial. And the jury convicts her on 4 felony counts and 3 misdemeanor counts.
And then the judge sentences her to 9 years in state prison.
9 years for a county clerk.
Yeah.
That is the initial outcome. But then we fast forward to April 2, 2026. The Colorado Court of Appeals steps in and vacates that 9-year sentence entirely.
Specifically on First Amendment grounds.
Right. And right now, as you and I are having this conversation, the case is sitting in a federal habeas posture in the District of Colorado.
And I think it is really important to clarify what that means for the listener, because a lot of people hear habeas corpus and they just assume it's like, another step in the standard appeals process.
Yeah, it's just appealing to the next higher court.
Exactly, but it isn't. Habeas corpus is basically the legal system's ultimate emergency brake.
Ooh, I like that term. Emergency brake.
Yeah, it is a civil proceeding where you are stepping completely outside of the normal state appellate ladder. You are going to a federal judge and you are asking, is the fundamental nature of this person's imprisonment unconstitutional?
Right.
You aren't just arguing that the trial judge made a minor procedural error, right? You are arguing that the state is holding a citizen in direct violation of the U.S. Constitution.
And the author of the brief we are analyzing, Tor, is actually the lead amici curiae, a friend of the court, in this federal habeas case, and they're representing over 3,000 co-signatories.
Wow.
But here is what really gripped me about this brief. The author doesn't just complain that the sentence was too long. That would be a standard argument. They zero in on the highly specific, incredibly paradoxical legal mechanism that produced that conviction and that sentence in the first place.
The treatment of intent.
Yes.
This is the doctrinal paradox at the very heart of the brief.
Let's unpack the concept of intent, because it is usually the whole ballgame in criminal law.
Right. It's what lawyers call mens rea, the guilty mind.
Exactly. Usually, to convict someone of a serious felony, you have to prove not just that they did a bad thing, but that they intended to do something illegal.
Yeah.
But at the Peters trial, according to the verifiable record, the prosecution advanced a very aggressive theory.
Very aggressive.
They argued that Peters' intent was completely legally irrelevant to the criminal elements of the charges.
They argued for a standard that is a lot closer to strict liability or a general intent paradigm. They essentially told the court, hey, it does not matter if Tina Peters genuinely, fervently believed she was performing her statutory duty as the legal custodian of those records.
Right.
Her belief is not a defense.
Okay, I want to make sure I have the mechanics of this straight. They are saying that if the state protocol says, do not image the machines, and she imaged the machines, the crime is complete.
Exactly.
Her internal motivation, whether she was trying to steal an election or trying to save the records for a future audit, is just invisible to the jury.
Perfectly stated. The prosecution successfully argued, and the trial court agreed, that the act itself, completely divorced from her perceived duty, was sufficient to meet the elements of the crime.
Wow.
So during the evidentiary phase of the trial, when the jury is sitting there deciding guilt or innocence, Peters' intent was structurally excluded. The jury was not asked to weigh whether she was trying to fulfill her oath of office. They were only asked to look at the timeline and say, did she authorize this specific action outside of the approved state checklist?
And the answer was yes.
Yes. Therefore, guilty.
Okay, so that gets the state their conviction, 4 felonies, 3 misdemeanors, but then the trial moves into the sentencing phase.
Right.
And this is where the contradiction becomes so glaring, it almost feels like a typo in the record.
It is where the bear trap just snaps shut. Because at sentencing, trial judges are granted incredibly broad discretion.
Right.
They are supposed to look at the whole person to determine the appropriate punishment. And the very same trial court that spent the entire trial ruling that Peter's intent was completely irrelevant to her guilt suddenly pivoted and reintroduced her intent as the primary justification for her punishment.
It wasn't just reintroduced, it was completely weaponized against her.
Oh, absolutely.
The brief notes that during sentencing, the judge called her a charlatan.
Right.
The court characterized her beliefs about her custodial duties as pretextual, malicious, and conspiratorial. The judge even referred to her preservation efforts as selling snake oil.
You can see the architectural vulnerability here. The court excluded the intent to ensure a streamlined conviction, basically removing the defense's ability to argue good faith. But then the court maximized the most negative possible interpretation of that exact same intent to ensure a severe 9-year punishment.
It's a heads I win, tails you lose scenario.
Perfectly said.
You can't use your beliefs as a shield during the trial to defend yourself, but the judge will absolutely use your beliefs as a sword to gut you during sentencing.
And this exact sequence is what the Colorado Court of Appeals flagged. That is why they vacated the sentence on April 2, 2026.
Right.
They ruled that the trial court violated the First Amendment by effectively punishing Peters for her protected speech and her political beliefs, beliefs which she wasn't even allowed to properly contextualize as a defense during the trial itself.
From a constitutional law perspective, that has got to be a highly volatile doctrine.
Oh, it is. When a trial court creates a system that silos intent, excluding it to lower the bar for conviction, but then exploiting it to raise the ceiling for punishment, appellate courts generally view that with extreme suspicion.
I would imagine so.
Because it looks less like the neutral application of law and more like the targeted punishment of a political actor. That is exactly why it is sitting in federal habeas right now. The constitutional viability of this intent-shifting doctrine is literally on trial.
Okay, I completely understand why the appellate court stepped in.
Yeah.
But I have to put my courtroom reporter hat back on here for a second.
Put it on.
Because I have sat through hundreds of criminal proceedings. And while this sounds uniquely sinister when we wrap it in the highly charged language of election integrity and First Amendment rights, I have to press the strongest prosecutorial counterargument. If we are analysts, we have to steelman the state of Colorado. We have to look at why a normal prosecutor would argue this was perfectly routine procedure.
Go for it. If we are going to buy into the author's theory that this is a structural suppression mechanism, we first have to try to break it with standard legal procedure.
Right. If I'm the prosecutor, I am looking at this outrage and I am saying, welcome to the criminal justice system. This happens every single day. We have crimes of strict liability and general intent all the time. Let me use an analogy to ground this. Let's say you are rushing your pregnant wife to the hospital.
Right.
She is in active labor. You are driving 90 miles an hour in a 65-mile-an-hour zone. A police officer pulls you over. You go to court. Your intent, your desperate, entirely understandable, even noble desire to get your wife medical care is completely legally irrelevant to the charge of speeding.
Because the radar gun says 90.
Exactly. The radar gun says 90. The sign says 65. You are guilty of speeding. Intent is excluded from the conviction.
That is the classic strict liability paradigm. The legislature has essentially decided that the act itself is so inherently dangerous that we don't care why you did it, we only care that you did it.
Right. But then you step in front of the traffic court judge for sentencing. And the judge looks at your driving record, looks at the dash cam footage, and says, "Sir, not only were you doing 90, but you were swerving onto the shoulder. You nearly hit a school bus, you flipped off the officer when he turned his lights on, and you showed a reckless, malicious disregard for the safety of everyone else on the road.
Yeah, that happens.
Your fine is maximized, and I am suspending your license." The judge is absolutely allowed to look at your attitude, your context, and your intent during sentencing to determine how severely you should be penalized, even though those things didn't matter for the initial conviction.
That is an excellent Steelman. I mean, the prosecution in Colorado would argue they aren't inventing some novel, sinister Peters doctrine to suppress election evidence.
They're just doing their jobs.
They are just applying standard, boring criminal procedure to a very loud, high-profile defendant. They would argue that holding the office of county clerk does not grant you magical immunity from the elements of a criminal statute.
No, it doesn't.
And holding idiosyncratic fringe beliefs about what your custodial duties are does not give you permission to violate state security protocols.
Right. They would say, did she break the protocol? Yes. Boom, convicted. Did she have a bad attitude and refuse to show remorse? Yes. Boom, maximum sentence. It is a harsh reality of the justice system, but it is not inherently an unconstitutional conspiracy.
But here is where the author of our brief counters that standard prosecutorial defense, because the author acknowledges that this mechanism exists in criminal law, but they point to the result of this specific application.
The outcome.
Right, what they call evidentiary silencing. They argue we need to look past the personal tragedy or personal culpability of Tina Peters for a moment, look strictly at the structural outcome of the litigation.
Okay.
The author highlights something incredibly stark. The actual forensic evidence that Peters preserved, the massive trove of data she risked everything to capture, was never ruled on.
Wait, it was never looked at by the court?
Never. The trial did not adjudicate whether Mesa County's election records actually contained anomalies. The trial did not adjudicate whether the state's trusted build procedure actually destroyed vital public records in violation of federal law.
Wow.
The trial only adjudicated whether Tina Peters had the correct administrative authority to look at the machines.
That's a huge distinction.
And by successfully criminalizing the custodian of the evidence, the legal system functionally silenced the evidence itself before any expert could analyze it, before any rebuttal could be offered, and before the public could see it.
Man, it's an incredibly effective quarantine. I mean, the brief explicitly states 5 years on, that material sits in exactly the condition it was in when it was preserved.
Right.
No court has issued a ruling saying, we looked at this data and it is invalid or corrupted. But equally, no court has said, this data is valid and shows irregularities. The court just sent the person who preserved it to prison and legally labeled her a charlatan.
Think about the chilling effect of that precedent.
Oh, it's massive.
If you are another county clerk somewhere else in the country, say in Nevada or Arizona or Wisconsin, and you are looking at your own voting systems, maybe you have concerns. Maybe you genuinely think you have a statutory duty to preserve a forensic image before the state rolled in to wipe the hard drives for the next election.
Are you going to stick your neck out and do what Tina Peters did?
Exactly. Are you?
Absolutely not. You'd have to be suicidal to try it. You just watched a colleague get handed a 9-year prison sentence, and her evidence didn't even get its day in court.
The deterrence is absolute. And that is the author's primary structural conclusion from this anchor case. This prosecutorial doctrine is a beautifully efficient weapon.
Yeah.
It doesn't need to prove the controversial evidence is wrong. It doesn't even need to examine the evidence. It just needs to prosecute the act of preservation itself.
Right.
Once the state secures that conviction, the evidence becomes instantly radioactive. Anyone who touches it, anyone who advocates for it in a courtroom is immediately associated with a convicted felon and a peddler of snake oil.
It neutralizes the evidentiary threat without ever confronting the evidence on its merits.
Exactly.
Okay, so let's summarize the foundation we've built here. We agree on the verifiable sequence of events in Colorado. The preservation happened, the trial happened, the conviction happened, the appellate court vacated the sentence on First Amendment grounds, and the fundamental constitutionality of this intent-shifting doctrine is currently locked in a brutal fight in federal habeas court.
That is all verified fact.
Right. But the author takes this localized Colorado doctrine and zooms out. They argue that if this doctrine successfully silences evidence in Colorado, it functions as a blueprint. And that logical leap takes us directly to the author's next major pillar, which is Pennsylvania.
And this is the segment where the brief requires the absolute utmost analytical precision from us as readers. Because we are wading into incredibly deep, incredibly murky waters here.
Very murky.
The author introduces the existence of preserved forensic images of Pennsylvania election system servers from the 2020 cycle.
Right. And we need to pause here and be highly, highly deliberate in pointing out what the author is claiming here and what they are explicitly not claiming.
Yes.
Because this document is not a broadside accusation of a stolen election. It is not a manifesto. The text is remarkably disciplined. The author states directly, and I'm paraphrasing a bit, but I am not claiming that the Pennsylvania material proves anything in particular about the 2020 election. I am not claiming that any specific anomaly is documented in it.
That is a crucial intellectual distinction. I mean, if you miss that, you misread the entire brief.
Exactly. The narrowest, most defensible claim being made by the author is simply this. The material exists.
Right.
A forensic preservation of Pennsylvania servers occurred during the 2020 cycle under similar principles of custodial duty that we saw in Mesa County. And crucially, for 5 years, it has never been adjudicated.
Yeah.
It has never been submitted into evidence, it has never been subjected to cross-examination by a neutral tribunal, and no judge has ever ruled on its contents.
And if we connect this back to the broader structural theme of the document, it is vital to understand that the author is making an argument about evidentiary process.
Not a substantive claim about the outcome of the election.
Right. They are pointing at a blind spot in the legal system. They are pointing at the system's structural refusal to look at the data. And the author's central thesis here is that the reason this Pennsylvania material has sat in a dark room for 5 years is because of the shadow cast by the Peters Doctrine.
It's the fear of prosecution. The fear that whoever steps forward to authenticate this data, whoever walks into a courthouse and says, I am the custodian of this server image, will be immediately criminalized and indicted before the data itself can even be opened and examined.
Precisely. The argument is that the prosecutorial architecture demonstrated in Colorado has successfully created a nationwide freeze on this specific class of digital evidence.
Yeah.
The material is functionally silenced by the threat of imprisonment, completely regardless of what the data actually shows.
Okay, but again, as analysts, we have to push back. We have to rigorously steelman the other side. Let's look at why a court or a state prosecutor or an election board might legitimately ignore this Pennsylvania evidence.
Right, because it doesn't have to be a grand, coordinated conspiracy of silence.
Exactly. There are very boring, highly technical, procedural reasons why evidence gets ignored or rejected by the legal system every single day. Let's start with the most obvious one, which is chain of custody.
The absolute bedrock of admissibility in any court.
Right. The author openly admits in the text that for reasons of custody chain integrity, they cannot publish the specifics of where this material is currently located or how it has been held for the last 5 years.
Which is convenient, but understandable from a security perspective.
True. But let's look at the reality of digital forensics. If this Pennsylvania material was preserved outside of the strictly approved, formalized protocols of the state election apparatus, much like the Mesa County data was, then any competent judge might look at it and throw it out immediately.
They wouldn't even need to invoke the Peters Doctrine. They would just invoke the federal rules of evidence.
Right. The judge would say, I don't care what your noble intent was. I don't care if you think you were doing your civic duty to save the republic. You broke the chain of custody.
You didn't use the state-approved right blockers?
You didn't maintain a continuous verifiable log of who had access to this hard drive for the last 60 months. Therefore, this data is fundamentally inadmissible.
Yeah.
It could theoretically be the most revealing, earth-shattering data in the history of the country. But if it spent a week sitting on an unauthorized laptop in someone's basement, the legal system cannot and will not accept it as reliable evidence.
That is a highly credible, entirely mundane counterargument. The rules of evidence exist for a very good reason.
They really do.
I mean, you cannot introduce a bloody knife into a murder trial if the lead detective took it home for the weekend and left it in his garage before logging it into the evidence locker.
Exactly. The defense would eat that alive.
The defense would instantly and successfully argue that the knife could have been tampered with, wiped, or altered. The exact same rigorous logic applies to digital forensics.
Right.
If the initial preservation method itself compromised the verifiable cryptographic integrity of the data, the courts aren't suppressing the evidence out of a conspiratorial fear. They are rejecting it based on standard evidentiary doctrine designed to prevent fabricated data from influencing a verdict.
Exactly. And then there is counterargument number 2, prosecutorial discretion. The author points to the absence of any adjudication regarding this PA data and says, look, it's a structural suppression. But prosecutors and attorneys general decline to take up cases all the time.
All the time. They have limited budgets. They have limited staff.
Right. They have a massive backlog of violent crimes, civil rights violations, corporate fraud, you name it. If a prosecutor looks at this Pennsylvania server data, assesses the massive chain of custody hurdles we just talked about, looks at the apocalyptic political explosion it would cause to bring it to trial, and decides, I don't have a viable slam dunk case here. That isn't necessarily a malicious silencing.
No.
That is just routine triage and prioritization by a busy office.
And counterargument number 3 is burden of proof. The American legal system is inherently adversarial. It places the burden entirely on the party advocating for the evidence to prove its value, its authenticity, and its admissibility.
Right. It's on you to prove it.
It is not the court's job to proactively go out and evaluate unsubmitted, procedurally flawed, or highly controversial data. The court is a passive referee.
Yeah, the judge sits on the bench and waits for the lawyers to bring the evidence to them in the correct format.
If the advocates for this Pennsylvania data cannot find a procedurally sound, legally bulletproof way to bring it before a judge, the system isn't broken. The advocates are just failing to meet their basic procedural burden.
Which brings us to a really interesting synthesis of this segment. Because both of these realities can be true at the exact same time.
Right.
It can be entirely true that the rigid rules of evidence and chain of custody make this data incredibly difficult, if not impossible, to admit in the standard hearing. And it can also be true, as the author argues, that the Peters doctrine has created such a terrifying deterrent, the threat of a decade in prison, that no one with the legal standing, the financial resources, and the technical expertise required to fight that uphill procedural battle is willing to risk it.
So the material sits in this murky, dark procedural limbo.
Exactly. It is trapped. The legal apparatus has created a perfectly sealed box.
It is trapped. But here's the author's next massive logical leap. If you are the apparatus that wants to keep this data trapped, if your entire strategy relies on maintaining this procedural limbo, you have a looming problem. Because eventually, smart, well-funded conservative lawyers are going to figure out a procedural workaround.
They always do.
They're going to find a sympathetic judge or a novel jurisdiction or an obscure legal theory that allows them to pry open that box and get this Pennsylvania data into a neutral tribunal. So if you're the apparatus, how do you stop them? How do you prevent that legal ingenuity from breaking your quarantine?
You don't just build a thicker wall. You build a decoy. You build a distraction so massive they can't look away from it.
Which brings us directly to the third and frankly most mind-bending pillar of this brief.
The Virginia Fulcrum.
This is where the structural analysis of the text really shines. It moves away from criminal law and steps into the grand strategy of high-stakes civil litigation.
Right.
The author proposes that the massive, highly publicized legal fight currently brewing over congressional redistricting in Virginia is not just a standard bare-knuckle political battle. They posit that it is a pre-engineered trap.
A trap designed to do one specific, devastating thing: consume the entire investigational, financial, and legal capacity of the American right for the next 12 to 18 months.
Let's lay out the reality of the procedural geography here. The Virginia case, on its face, is about whether a state legislature can use a mid-decade referendum to redraw congressional districts, potentially erasing the representation of a regionally coherent minority group.
Right.
As the author acknowledges right in the opening sentence of the brief, that is a profoundly real constitutional question. It has massive implications for the balance of power in Congress. It warrants serious, top-tier litigation.
Oh, it's a huge deal. I mean, if this goes to trial, you're going to have state attorneys general involved. The DOJ's Civil Rights Division is going to weigh in. You'll have top-tier private election law firms billing thousands of dollars an hour, massive super PACs funding the research. Everyone who is anyone in the election law space is going to be descending on Virginia.
It will be the Super Bowl of election law for the next year.
Exactly.
But look at the specific bodies of law that govern that Virginia courtroom. This is the critical doctrinal insight the author is offering. The Virginia fight will be litigated under redistricting law. It will be litigated under the Voting Rights Act.
Right.
It will be litigated under 14th Amendment equal protection doctrine and under the specific, highly complex rules governing partisan and racial gerrymandering.
Okay, let's slow down and translate that for the listener. Why does it matter which laws are being used in that courtroom?
Well, think of jurisdiction like playing a highly regulated game. Let's say you are sitting down to play a game of chess.
Okay.
You can have the best poker hand in the world in your pocket, like a royal flush of server data. But the moment you sit down at the chessboard, the referee is going to tell you your cards are completely useless.
Because you can't use poker cards to capture a knight.
Exactly. The court simply doesn't have the legal software, the jurisdiction, to process that specific type of evidence.
A jurisdictional mismatch.
Yes. A federal court only has the authority, the jurisdiction, to hear evidence that is strictly relevant to these specific legal claims being brought before it in that particular complaint.
Okay.
If you are in a federal court arguing that a new map drawn by the Virginia legislature violates the Voting Rights Act by diluting minority voting power, The evidence you bring is demographic data.
Right, census stuff.
You bring historical voting patterns, you bring census tracts, you bring emails from lawmakers showing discriminatory intent, you bring maps.
You argue about lines on a piece of paper in demographic populations.
Yes. What you absolutely unequivocally cannot bring, because it is a jurisdictional and doctrinal impossibility, is preserved forensic server material from a completely different state, Pennsylvania, from a completely different election cycle, 2020, concerning a completely different legal theory, custodial preservation, cyber vulnerabilities, and potential fraud.
Man, the judge in the Virginia redistricting case would laugh you out of the courtroom. If you tried to introduce a hard drive from Pennsylvania 2020 into a hearing about Virginia 2025 district lines, opposing counsel would object on relevance grounds before you even finished your sentence.
And the judge would sustain it immediately.
Yeah, the judge would say, "Counsel, this data has absolutely zero relevance to whether these maps violate the Equal Protection Clause. Sit down."
So it is legally, structurally impossible to introduce the Pennsylvania material into the Virginia fight. The courtroom in Virginia has a bouncer at the door, and the Pennsylvania data is not on the list.
And this leads to what I think is the author's most brilliant structural inference. It's what they call the win-lose fallacy.
Yeah.
The author writes, "The choreography is not Virginia loses, conservatives win. The choreography is also not Virginia wins, conservatives lose."
The outcome of the verdict is entirely irrelevant to the function of the trap.
Because the choreography is exactly the same regardless of who wins the case. For an entire year, all the money, all the investigational time, and all the elite top-tier legal minds of the conservative election integrity movement are voluntarily locked inside a courtroom that is structurally forbidden from looking at the 2020 evidence.
In military or strategic terms, it is what we call a capacity sink.
A capacity sink.
Legal talent and investigational resources are finite. There are only so many elite lawyers in the country capable of litigating these incredibly complex, high-stakes election issues. There are only so many millions of dollars available to fund them.
Right.
If the best legal minds on the right are spending 80 hours a week deposing map makers in Richmond, Virginia, reading demographic studies, and writing appellate briefs about the Voting Rights Act, they are inherently not drafting the novel federal habeas petitions needed to break the Peters Doctrine in Colorado.
Wow.
And they are not building the complex procedural framework required to authenticate the server data in Pennsylvania.
It's a massive, brilliant misdirection play, assuming the author's theory holds. The trap isn't that the conservative lawyers might lose the Virginia case. The trap is that they're fighting the Virginia case at all.
Exactly.
The trap is the total consumption of their capacity. The author is essentially saying, you are walking into a massive coliseum to fight a gladiator. You are putting all your armor on, you are training for the fight, the crowds are cheering. But while you are entirely distracted by the spectacle of the battle, the real evidence is quietly decaying in the vaults outside.
And the ultimate protected target of this decoy operation, according to the brief, is the Peters Doctrine itself.
Right.
The longer the legal apparatus is distracted by the fireworks in Virginia, the longer the precedent set in Colorado stands unchallenged in the broader legal culture, and the longer the Pennsylvania material remains completely silenced by the threat of prosecution.
Okay, I have to admit this is an incredibly elegant structural theory. It makes a chilling amount of logical sense on paper. You tie up your opponent's best fighters in a battle they can't use their best weapons in, but for this to be a coordinated trap, rather than just a massive coincidence of timing, because, let's be honest, big, complex legal cases happen organically all the time.
They do.
There has to be some kind of operational evidence. Someone has to be managing this choreography on the ground. The author argues that this isn't just an accidental emergent quirk of the legal system. It is being actively, nervously managed by human actors who know the clock is ticking.
Which brings us to the fourth and final segment of our deep dive.
The Schiller question and the ticking clock.
This is where the document undergoes a radical shift in tone. It moves away from abstract legal theory and jurisdictional analysis, and it steps directly into operational intelligence and cybersecurity tradecraft.
Yeah.
And it introduces a very different, much more urgent kind of tension.
Yeah, if you are reading the brief, it feels like it takes a hard turn.
Yeah.
But logically, it connects perfectly. Because if this trap in Virginia relies on complete operational secrecy to work, then any panic or sudden shifts within the opposing coalition's communication networks tells us something crucial. The author introduces whistleblower allegations made by a man named Tom Schiller. Now, The brief explicitly states that the substantive details of Schiller's allegations, which apparently involve Microsoft, China-based software engineers working on Department of Defense contracts, and vulnerabilities in Azure cloud systems.
Quite the list.
Yeah, those are outside the scope of this specific procedural document and will be detailed elsewhere. But what the author extracts from those allegations is a behavioral pattern, an operational tell.
The author is looking at the movement and the specific advisory behavior of intelligence community figures within this operational coalition. And they highlight a glaring, almost absurd technical asymmetry in the cybersecurity advice these figures are giving to their own people.
Right. According to the text, these intelligence figures are going around their coalition telling people not to worry too much about what they call endpoint compromise. But they are simultaneously aggressively hyping up the terrifying dangers of transport layer attacks.
And for the listener who isn't a cybersecurity professional, let's break down those terms so this makes sense.
Please do.
It is a critical distinction to grasp. A transport layer attack is essentially intercepting a message while it is moving from point A to point B. It is a man-in-the-middle attack.
Okay.
If you send an unencrypted text message over a cellular network, someone with the right equipment sniffing that network can read the message while it is in transit.
Right.
An endpoint compromise, on the other hand, is when the actual device itself, the physical iPhone, the laptop, the server in the basement, is hacked or physically monitored.
Yeah.
If an adversary has compromised your endpoint, they have a keylogger installed or screen capture malware. They don't need to intercept the message in transit. They can just read it on your screen as you type it before it's even sent.
Okay, so I want to use an analogy here to explain why the author finds this specific advice so incredibly suspicious. The brief notes that, based on this advice, the coalition is currently in a panicked rush to migrate their internal communications off of a platform called Matrix and onto an encrypted app called Signal. And Signal is famous in the cybersecurity world for its incredibly robust transport layer encryption. It is mathematically very secure while the data is in transit.
Right. But let's imagine you are running a bank and you need to move $1 million in cash from the downtown branch to the uptown branch.
Right.
A transport layer attack is like a gang of highway robbers ambushing the truck on the freeway. So to prevent that, you go out and buy a state-of-the-art, impenetrable, military-grade armored convoy. That armored convoy is Signal.
Makes sense.
You are perfectly protected in transit. No one is robbing that truck on the highway. But an endpoint compromise means that the bank tellers at both branches are actually undercover members of the robbery gang.
Ah, I see where you're going with this.
If your endpoints are compromised, the armored convoy is completely useless. The robbers just pack the money into the truck at the downtown branch, drive it safely across town, and their buddies unload it directly into their own pockets at the uptown branch.
Yeah.
If you suspect your endpoints are compromised, upgrading your transport layer to a stronger armored truck does absolutely nothing to secure your operation. It is security theater.
And that is exactly the author's point. The author states that transport layer attacks are a known, relatively well-defended class of threat. But endpoint compromise is a much more difficult, much more insidious problem.
Yeah.
And crucially, it is a highly sensitive issue for intelligence actors because they rely on plausible deniability about their own domestic surveillance capabilities, which often rely on endpoint access.
Right. The brief lays out the logic beautifully. When a figure with an intelligence community background advises a coalition not to be too hung up on transport layer vulnerabilities while exhibiting evasiveness about endpoint vulnerabilities, the inference available is that endpoint compromise is either a known issue the figure does not want discussed openly, or, much more concerning, that endpoint compromise is operationally expected by the apparatus.
So the rushed migration to Signal in this context is a misdirection. If you are genuinely worried about insider threats, hardware backdoors, or endpoint hacks, moving your chat app to Signal doesn't solve your underlying problem.
No.
But the act of the rush migration, the sudden, frantic need to change protocols, tells the author something vital about the psychological mindset of the senior leadership running the trap.
It's the tell. Just like in poker.
It's the tell. It indicates that at the senior level of this operation, there is sudden, acute panic about communications integrity. They are tightening their operational discipline on a highly compressed timeline. The author infers that these actors know adversarial scrutiny is imminent.
They know they're being watched.
They know someone is looking at them, even if that scrutiny hasn't hit the front pages of the newspapers yet.
Right. They know the trap they set in Virginia is in danger of being exposed, so they are scrambling to lock down the communications protocols before the conservative lawyers realize they are being played. Which leads to the author's final dramatic move, the call to action.
And it is a fascinating, highly unconventional strategic choice for a published document.
It really is.
The author explicitly states that they have developed a procedural strategy, a specific, actionable legal mechanism to link the Virginia redistricting fight directly to the adjudication of the Peters Doctrine and the Pennsylvania server material.
Right.
They claim they have figured out the precise legal geometry required to build the courtroom that can actually hear all the evidence at once.
But they refuse to publish the strategy in this document.
Exactly. They state that the strategy is contained in a separate private briefing memorandum, and it is intended for hand-to-hand delivery, old-school, physical delivery, no emails, no signal messages to key officials.
Like who?
State attorneys general, DOJ civil rights professionals, congressional oversight staff, and the specific legal team currently handling the Peters habeas case in Colorado.
When I first read that, my immediate thought was, why not just publish it? If you have the silver bullet, if you know how to break the trap, why keep it secret? Just put it on the internet.
Right, that's the instinct.
But the author explains their reasoning, and it tracks with the rest of the document's logic. They write, the strategy works because the apparatus on the other side has not yet built procedural countermeasures against it. Publishing it here would surrender that advantage. Holding it for direct delivery preserves the mechanism. It's entirely about maintaining the element of tactical surprise.
It is a stark reminder to the reader that this isn't an academic exercise for the author. This isn't a think piece. This is active, ongoing legal combat.
Yeah.
They are treating this procedural strategy like a classified weapons system.
Yeah.
You don't publish the schematics of the missile before you fire it, and they put a hard, unyielding clock on the whole operation.
The Mayday deadline.
Yeah.
The brief ends with a warning that the operational window is closing rapidly. It says Mayday is in 7 days. After Mayday, the deployment begins. The window for procedural action that precedes the deployment rather than reacts to it is now. They are telling these attorneys general and these lawyers, I have the map out of the maze, but you have to act immediately because in 7 days, the decoy operation in Virginia goes fully live and you will be trapped in that capacity sink for a year.
It is a truly remarkable piece of document design. Just look at the journey we've taken today. It moves from a granular, microscopic analysis of a single Colorado sentencing hearing.
Right.
It extrapolates a nationwide prosecutorial doctrine from that hearing. It maps exactly how that doctrine functionally silences specific evidentiary material sitting in Pennsylvania. It diagnoses a massive multi-million-dollar decoy operation in Virginia designed to protect that specific doctrine.
It's all connected.
It identifies operational panic in the cybersecurity protocols of the opposing coalition, and it ends with a ticking clock ultimatum and a secret tactical memo.
Which brings us to the end of our deep dive. As we wrap up this analysis of Fulcrum2.pdf, I want to remind you, the listener, of the elegance of the author's central thesis. Because regardless of where you stand on the politics of the 2020 election, regardless of whether you think Tina Peters is a hero or a criminal, the structural critique presented in this document is incredibly sharp.
It really is.
The author states it perfectly at the very end. It's not the story they tell you that is important, it's what they omit.
The text is ultimately a masterclass in jurisdictional boundary reading. It is a study in the weaponization of legal procedure. It forcefully challenges the public assumption that the most important legal battles are the ones dominating the headlines in cable news.
It argues that the headline is the distraction. The real war, the war that actually dictates the future of the country, is being fought in the quiet structural mechanics of what evidence is even allowed to be entered into the record in the first place. So as we close, I want to hand it over to you for a final thought. We've unpacked the text. We've maintained the analytical discipline. We've looked at the facts.
Yeah.
What is the lingering question this leaves you with?
Well, if we step back from the specific document and from the highly charged specific controversies of election integrity, the author leaves us with a profound, almost unsettling structural question to chew on.
Okay.
If they are right, if it is practically possible that immense multi-million-dollar legal battles like the Virginia redistricting fight can be engineered entirely as capacity sinks to protect completely unrelated legal doctrines, How much of modern high-stakes American litigation is actually just shadowboxing?
Wow.
Are the most important legal questions of our time being decided not by the brilliant, impassioned arguments made inside the courtroom, but by the invisible architecture that decides which courtrooms we are even allowed to fight in?
It's muddy waters. And the clean, predictable lines we expect the legal system to provide might just be the very lines drawn to keep us looking in the wrong direction. Until next time, keep reading the fine print.
Six parts, one companion piece, 100,000 words on the record.
Seven federal statutes, the same elements analysis, applied symmetrically to both sides of the architecture.
It's not the story they tell you that is important. It's what they omit.
The more you know.